We are now recording.
All right. Good morning, everyone. Welcome to the meeting of the Board Executive Committee of the State Bar Board of Trustees. And as a reminder, this meeting is being recorded. Start things off, if I could have our secretary, Louisa, please take our roll call.
10, not present. Cisneros.
Here.
Good, not present. Shelby, not present. Soel.
Present.
Stallings.
Present.
Tony.
Present.
Trejo. You have a quorum. I see Trustee Trejo is here.
Yes. Let the record reflect that he waved with his right hand and pointed to his headphones so he can hear us. All right. Next on the agenda is call for public comment. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. For those of you who are participating by Zoom video, you should have a function by virtually raising your hand. And then for those of you participating by phone, you may virtually raise your hand by pressing *9. Due to time restrictions, we cannot allow for more than 3 minutes for each speaker. And I will first go to any individuals who signed up ahead of time. Madam Secretary, do we have anybody who signed up ahead of time?
Not for the executive committee.
All right. And then so now just make a general call for public comment. Any of our attendees wish to address the executive committee on any matters before us and agendized.
We have a few hand raised. First one is Taboo Wilson.
Good morning, everybody. How are we all doing today? We getting ready for a great Thanksgiving? Now, Leah, I just don't know if you've gotten my emails as of yet. You know I'm asking that you reassign Shane to somebody different, right? I mean, he's an Arizona lawyer. Why are we using Arizona lawyers for special deputies? Can't you find anybody inside of California? Leah, are you going to look at me or talk to me?
Taboo Wilson, you may address the executive committee.
Oh, okay, Brandon, let me ask you a question. You are a prosecutor, correct?
Sir, this is your chance to make public comment.
Yeah, my question to you is, if you came across a police report that had been redacted beyond repair, what would you do with that report? Would you investigate it, or would you just say, no, thank you, I'm not going to bother even investigating that? What would your ethics tell you to do, Brandon?
Sir, this is your chance to address the executive committee, and as a prosecutor,
I'm asking you a question on ethics, because that's a big question for everybody nowadays, right? Would you review that report? Would you investigate why that report had been redacted after it had been filed? I mean, isn't that like just protecting a third party, protecting people, Leah? Isn't that what that redaction was to do, was to protect Vanessa? So how do you ever think we're going to have any belief in your ethics whatsoever if you can't even basically follow the law? Come on. Vanessa Holton never should have filed that report. I shouldn't be writing the stuff that I'm writing now, but Lee, I'm going to tell you, I'm having a lot of fun doing it. And my book will be going out. I've already got approval from this place called Smashwords. They like what I've written so far. So I'm going to have fun, but I don't know if you saw the latest. You know, what happens to Paul Pelosi's trial? That's going to be fun. I will talk to you soon. Thank you.
I thank you for your public comment.
Next, we have Tyler G.
All right. Welcome, Kyler Jean. Can you hear us?
Yes. Can you hear me?
Yes. Please proceed, sir.
I am a first-generation law student, a working parent of differently abled children, a disabled veteran, and a CBA graduate. My path to the legal practice has been intertwined with intense personal challenges. While preparing for the bar exam, my middle son received an autism diagnosis, and my family scrambled to wrap supports and services around him. On February 28th, 2023, Rare Diseases Day, my youngest, Leah, was born, and 5 months later, he was diagnosed with a rare brain cancer, specifically a grapefruit-sized choroid plexus carcinoma. We spent months at Stanford Children's Hospital and the Ronald McDonald House, leading to a life-saving surgery by the chief of neurosurgery at St. Jude's. But Leo's journey is far from over. He will endure ongoing medical surveillance, including abdominal ultrasounds every 3 months, brain scans every 6 months, and full body MRIs annually for the rest of his life. I've been practicing as a provisionally licensed lawyer. I received my license on February 5th, 2021, and from that date, I've managed to juggle my professional responsibilities amidst personal upheaval. The week before my son's surgery, I had day one of a complex child custody move away trial, and day two followed the Monday after that surgery, and I'm confidently awaiting the judge's written statement of decision. The PBE is not a dilution of legal standards, as some suggest. Rather, it is an acknowledgement of the diverse and often arduous paths many of us traverse in our legal journey. It recognizes the dedication and competence of those who have consistently demonstrated their legal acumen under challenging circumstances. The PBE is also an acknowledgement that the bar exam itself is not the best way to measure minimum competency. My progression from a law clerk earning $20 per hour to a salaried junior associate, and then a position where I now earn a significant salary plus bonuses, was not a gift, and I am not indentured to anyone. It was a result of relentless hard work amidst a backdrop of personal challenges that few can imagine. And when I hear PBE criticized as being dumbing down the profession, I cannot help but reflect on my own journey. The PBE is a necessary evolution in legal education and licensure, reflecting the realities of today's diverse and multifaceted world. It is an opportunity for the legal profession to embrace and support those who have proven their mettle in ways that go beyond traditional paths. In closing, I urge the board to consider the PBE not just as a temporary measure, but as a visionary step towards more inclusive, equitable, and realistic approach to the legal practice. It is about opening doors, recognizing effort, and valuing a diverse experience that enriches our profession. Thank you for your commitment to this cause and for recognizing the potential that programs like the PBE hold for the future of our legal community. Thank you.
All right, thank you, sir.
Next, we have Sabrina Green, CLA Vice President.
All right, welcome. Ms.
Morning,
Green.
can you hear me?
Yes, we can.
Good morning, everyone. My name is Sabrina Green. I'm the immediate past chair and current vice president of the California Lawyers Association. Thank you for the opportunity for us to provide a few comments on the very important issue of the proposed portfolio bar exam. Throughout the Blue Ribbon Commission, the subsequent BRC, CLA has expressed its opposition for a non-exam pathway to licensure. It is noted that BRC did not advance any recommendation regarding an alternate bar exam, and CLA endorsed that decision not to advance an alternative pathway that did not include a full bar exam. And now we are gravely concerned because the proposed portfolio bar examination includes the term bar examination that mirrors the same proposals BRC did not recommend as an alternative to the current bar exam. We understand that the California bar exam is not a perfect testing vehicle and that CLA is certainly willing to consider some practice exam components, but in addition to, not instead of the bar exam. We're concerned because the proposed PBE completely eliminates objective and uniform testing, raising significant integrity terms that are impossible to manage. And we believe the proposed PBE will have very dire impacts on efforts to increase diversity in our legal profession. In the standard bar exam testing, everyone is in the same room and provided with the same tests, same time, same materials and questions, and that utilizes only that applicant's skill and knowledge, and thus that provides consistency. Per the PBE, work product by definition is not the applicant's work alone. It can be other attorneys, it can be artificial intelligence, bar materials, or even other attorneys' work product entirely. This provides absolutely no consistency or integrity and is frankly just not possible to even manage, just like it would not even be possible to glean a supervisor who intentionally or not intentionally misrepresents a candidate's work product. There is simply no effective monitoring or quality control of all the components proposed under the PBE that could adequately ensure the candidate is competent in and of themselves alone to practice law. As for the objective assessment component, that staff recommends the proposal be augmented with by a component of up to 2 performance tests as they set forth on page 6 of the report. It raises the question, why wouldn't the candidate just then take the bar exam? To do so would address the concerns noted and again provide for consistency in scoring and application. Finally, CLA does not believe any of these measures in the proposed PBE will increase diversity in our profession and in fact may cause the opposite effect. We appreciate the time and effort that went into this report. However, CLA is strongly opposed to the alternative pathway to licensure working group's proposal or the court.
Next, we have Charlene Claish. I apologize if I mispronounced your name.
Hi there. Can you hear me okay?
Yes.
You said my name. Great. Thank you. I'm going to try and do this quickly. First, I would really like to request that I would like to submit something to take screenshots because I've been coming to these meetings for the last 4 years and it still takes me 15 minutes to find the link for the agenda. It feels like it's being hidden on the days of the meetings because it seems a lot easier for me to find it on non-meeting days. So what I'd like to do is I'll send something by email. I'll take screenshots. It takes me 4 to 8 layers of to find the link to these meetings. So I find that a little concerning because people that want to participate, including the public, it's very, very difficult to find the links for these meetings and the agendas. So side note, as far as the portfolio, I think it's a great idea to find alternative pathways because I am somebody who is very well educated. I've taught high school. I've worked as a private investigator. I'm a former elected official. I am a, I've been appointed to various local government entities. I've worked on several political campaigns. I helped a judge get elected, the first woman of color get elected to the Marin County judicial ship. So alternative pathways are great because not everybody is good at taking tests. Women are known to not do as well on multiple choice questions because we overthink things, which is good in many, many contexts. What I'd like to suggest, because the portfolio pathway, I don't know how you're going to keep it fair. It's going to discriminate against people that need to keep working their full-time jobs. How much are you going to require attorneys to pay these people in the portfolio program? Is it going to be minimum wage? How many hours are they expected to work on a week? Which attorneys are going to be authorized to be supervisors? How much input will these individual attorneys give to the work product that's going to be included in the portfolio? What are you going to require to be in the portfolio? Is it going to be the same for every person? How are you going to grade them? These are all really serious questions that I hope are being thoughtfully addressed. Who's going to grade them? Which assignments? How much additional input are they going to get? Is it going to be a brief? Is it going to be a demur? Is it going to be, it's going to be very different. And a side note, sorry, my dog thinks every time I'm talking to somebody, I'm talking to her. On a side note, law schools, many law schools do not teach any of these skills. We are not paralegals. These are things that are taught in paralegal program. So I even asked my dean of my school if I could take paralegal program courses during law school, and they laughed at me because I knew this was going to be vital because I'm older. I'm 54 years old. So I know what's required in the actual law office setting. I worked for a big law for class action mass torts. I helped make them $50 million for the Camp Fire in Northern California and the North Bay fires. I know what's needed. I'm sorry, but try the licensing pathway.
All right, thank you for your public comments. I would just note for our attendees that the portfolio bar exam item will be taken up at the full board agenda, which is set to start at approximately 12:30 p.m. this afternoon.
Next, we have Rianne Pacheco.
All right, Rianne Pacheco, can you hear us?
Yes. Hi, good morning, Board of Trustees, and thank you for the opportunity to comment today. My name is Rianne Pacheco. I'm with the Legal Aid Association of California. We are commenting in support of item 701, the proposal for the portfolio bar exam. We did submit written comment, but I just want to highlight a couple of things. We believe the legal service providers are experts in understanding the legal needs of Californians, and without our voice, you'll be missing an important and necessary perspective. We folded in dozens of provisionally licensed lawyers in 2020 when you understand deeply what types of supervision is needed to in order to ensure client protection. So ultimately, we recommend that legal service providers and access to justice stakeholders serve on the program design committee, and that the PBE be piloted in IOLTA funded organizations. These 110 nonprofits already receive significant monitoring by the state bar staff. We believe legal service providers are experts in understanding legal needs of Californians, and that a portfolio bar exam is not only more equitable, but than the traditional bar exam, but we believe it is a better indication of whether someone meets the minimum competence to be a licensed attorney. Many of the voices you are hearing from the opposing side are private attorneys, perhaps unaware of the recruitment and retention crisis the legal aid sector is experiencing and how that impacts our ability to serve lower income Californians. We strongly believe that the alternative pathway to licensure can help bridge the justice gap in many ways. Not only will it allow for more people to see themselves as attorneys because the fear of failing a bar exam has been deterrent for many, but it will lead to a more appropriate representation of Californians in the legal profession. I yield the rest of my time to Claire.
Thank you, Ms. Pacheco.
Next, we have Ray Hayden.
Hi, I hope that everybody can hear me okay, because I'm trying to experiment with my laptop here. First thing is, I just want to make it clear that I support the PBE alternative simply because something's better than nothing, but I always knew it was going to be a really hard uphill climb for them. But secondly, and more importantly, to save time for your part of the meeting, we can make these public comments specifically at that time. Is that not correct?
That's correct.
Okay, so I'm going to cut that short right now and save the time that for the PBE stuff, I want to make that public comment at that time. Thank you very much for that clarification.
Absolutely. Thank you for your comment.
We do not have any other members who wish to address the committee.
All right. Thank you, everyone, for your public comments. We look forward to a more robust conversation later on down the road, around 12:30 this afternoon, about many of the comments you made about the portfolio bar exam. I want to go to our next agenda item, which is the chair's report. I will yield that report or move that report to the beginning of the Board of Trustees agenda. Move now to minutes. This is the approval of the September 21st, 2023 open session minutes. And would just ask members of the committee if there are any corrections or modification to these minutes. And if none, may I ask for a motion and a second?
I'll move the minutes.
A second?
All
Sorry.
right, is there a second? All right, was that a second by Mr. Tony? All right.
I was on mute. Sorry about that.
All right. All a little rusty here on a Thursday morning. All right, first by Trustee Sewell, second by Trustee Tony. May I have the roll call, please?
Chen, not present. Cisneros.
Aye.
Good, not present. Shelby, not present. Sewell.
Aye.
Tony.
Aye.
Trejo.
Aye.
Stallings.
Aye.
5 ayes, 0 nays. Minutes are adopted.
All right, thank you. Next is our business item. We have one agenda item, and that is the approval and ratification of amendments to the board policy manual. And this item is being presented by our board secretary, Brady Dewar, and our general counsel, Ms. Deftian.
Yes, thank you so much. I will kick this off and then hand it off to General Counsel Deftian. Today's item is a request for approval of revisions to the board policy manual. Just very briefly, the key changes include adding a new section to summarize the responsibilities and oversight of the Special Deputy Trial Counsel Administrator for the Rule 221 program. This section builds on the rule provisions by describing the process for policy adoption within the program. Most notable component is the revision that the Special Deputy Trial Counsel, as an administrator, is able to develop policies that mirror or are consistent with State Bar and OCTC policies, and shall raise any deviations to the Rule 2201 Discipline Liaison. Second revision is the sections on evaluating the Executive Director, General Counsel, and Chief Trial Counsel to streamline the process. The revisions provide time and language. I will now turn it over to General Counsel Dafton, who will provide further details.
Thank you. Good afternoon, Chair and members of the committee. I will keep my presentation brief, as I understand a more detailed discussion may occur at the board meeting. I'll speak to, at a high level, about two subjects that are revised in the board policy manual. One pertains to conflict of interest revisions. A bulk of those revisions were aimed to align the policy with the recent legislative amendments advocated by the board and included in our fee bill SB 40. Additionally, the revisions include procedures for actions that the board could take if and when appropriate, there is a determination that a trustee violated conflict of interest rules. These include and span from taking no action if there's no finding of conflicts, or making an admonition, sanction, or censure. These procedures are outlined in the new revisions in the board policy manual. Additionally, there is a process included for allowing the board to disqualify a trustee in situations where a trustee's involvement in the decision may result in violation of conflicts rules. The second set of revisions pertains to settlement authority, and really these are a lot of cleanup type of revisions to make it clear that the general counsel has authority to settle claims against the state bar in the amount not to exceed $25,000, and to allow the general counsel to reject settlement offers that are unreasonable and are above the $25,000, are valued less than $25,000. Clarifying revisions also include the flexibility for the executive committee to approve and make recommendations to the board where appropriate on settlement. Finally, revisions also include reporting requirements for the general counsel to the board to provide transparency.
All right, thank you. Any questions for staff or comments? All right, can we have the resolution put up on the screen?
I do have a comment
Yes.
that I would like to make. I spent a lot of time looking at this, and I have to tell you, I'm in very strong support of it. I'm not going to go into the reasons now because I want to reserve that for the discussion at the full board meeting. And I think that particularly there should be a discussion for all board members on the conflicts of interest, because it pertains to everybody, not just executive committee members. And I note that this process has occurred over a long period of time. And in that period of time, since we started discussing the conflicts of interest, probably close to 2 years, there have been several newer board members, trustees that have been appointed. And I think they would benefit from a discussion. So I would like to recommend that it's not necessary for the executive committee to recommend. I would not be in favor because I really feel that the whole board of trustees should, in the discussion, be engaged and make that decision on their own. That's just my feeling. I just wanted to put it out there that I think it's more appropriate for this vote to happen after the discussion, the full discussion.
I think, your comment is well received. I can think back to discussions we've had at executive committee where that has not tempered the discussion with the full board. And so I understand your concern, but think that what this vote does is it sends a message to the public and to our stakeholders that every level of the Board of Trustees is taking this matter seriously, and we're moving it along to a full vote on the Board of Trustees.
I appreciate that. I would suggest that this is an agenda item that I believe is not appropriate to be on the executive committee agenda, because it is of concern to the entire. Really, it's the conflicts of interest and how deep the changes are. These are profound. These are paradigm shifting changes. I believe that if the conflicts of interest weren't on here, then I think it would have been fine. I would have had no objection. I think this is a special case, is what I'm trying to say. These are profound changes in the conflicts of interest. These are not minor tweaks, and they're important, and I support them, but I do not support them being on the agenda for the executive committee, which is why, as you suggested, I was the one that indicated that I will ask for the item to be taken off the consent agenda so that I can have a full discussion. So I will not be supporting this if it comes up for a vote now at the executive committee. It will not have my support.
Understood. And I think our general counsel has her hand raised.
I thank you. I just wanted to point out a procedural requirement that's included in our executive committee's charter. In fact, executive committee is charged with approving the amendments to the board and then moving them forward to the board. So for ratification. So, I think it would be important to follow that procedure, and it will still give the board the opportunity to fully weigh in on the conflicts provisions, because they would still need to take a vote to ratify the recommendations from the executive committee. So if the item is pulled from the consent agenda, then the board could have a full discussion and then take a vote, with the benefit of having the executive committee also move this item forward to the board.
All right, thank you. Any other comments? All right, may I have a motion and a second?
I'll move the item.
I'll second.
All right, first by Vice Chair Cisneros, second by Trustee Trejo. I have a roll call.
Chen, not present. Cisneros.
Aye.
Good, not present. Shelby, not present. Sowell.
Aye.
Tony.
No.
Trejo.
Aye.
Stallings.
Aye.
4 ayes, 1 no. Motion carries.
All right, thank you. We are now going to be moving into closed session. This is pursuant to Government Code Section 11126 sub A, and we will consider the sole item on our closed session agenda, which is discussion of performance evaluation of general counsel. We're slated to come out of closed session at approximately 9:45. Given public comments, I think that we may come out a little bit after 9:45, but please plan on being back on at 9:45, where we'll go back into open session. Trustee members, you should receive a closed session link, and we will adjourn into closed session. Thank you.
Thanks so much.
We are now recording.
Mary, we're still in XCOM. We're just going to close this out and then it'll be finance.
Okay. All right, this is Brandon Stallings, Board of Trustees. We are out of closed session for the Executive Committee portion of the agenda. There are no reportable actions to make at this time, and so we'll adjourn the Executive Committee meeting and start up with the Finance Committee meeting. So thank you, and we'll see you soon.